Please be seated. We'll hear argument in case number 240045, K&K Inez Properties versus Kolle.
Court. Ms. Clothier will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, may it please the court. I plan to start with the issue of striking Victoria County as the responsible third party. Here in the Court of Appeals, the issue is that the gatekeeping function for striking a responsible third party falls under Section 33.004, and it requires minimal evidence because the statute only says that if it can be stricken if there's no evidence that a designated person is responsible. But here in the Court of Appeals actually used Section 33.003 in analyzing whether or not to reverse on this issue.
But isn't that because 33003 tells us when a party is responsible?
It does, but it is very specific. The legislature states that the trier of fact is the one who determines. It specifically says the trier of fact determines the percentage of responsibility under 33.003, not the court. So
right. So if you're right that Victoria County shouldn't have been stricken, then they would have been submitted in that proportionate responsibility question and asked. The jury would have been asked what, to what percentage did they cause or contribute to cause in any way the harm by violating an applicable legal standard. So the question for the court in allowing the jury to answer that has to be what legal standard did they violate? Is there evidence that they violated a legal standard? Otherwise, there's no point in asking the jury to think about that.
I respectfully disagree with that. I think that the Court of Appeals has to review the issue under the standard in which the trial court was required to decide whether or not to strike the responsible third party, which is under Section 33.004. And the only person or party that was responsible for making that determination is actually the trier of fact of the jury in this case. So the Court of Appeals did not have the right to step into the shoes of the jury. They only had the right to actually analyze it from did the trial court err when it struck that responsible third party under 33.004?
Does the evidence that you say should have gotten this RTP onto the charge essentially boil down to 2 different people, one county commissioner, one engineer, saying it was imprudent, in quotes, imprudent, not to continue with the digging and the widening? Or is there more? First of all, do you agree that that's what the focus?
That's the primary issue that we contend, but it has to do with the fact that they should not have started the project if they had not received permission from all the downstream properties.
Right.
So because they did the digging on the upstream properties, it caused the flooding of our client, the petitioners, and the respondents' property.
Yes, but is the testimony that you rely on for that theory,
for the expert testimony,
those 2 gentlemen saying that it was imprudent to do that?
Correct.
Nothing else?
I believe that was the primary testimony.
And do you think that that is evidence of negligence, some evidence of negligence?
It meets the standard under 33.004 because it says there must be no evidence that the designated person is responsible for any portion of the damages.
Okay. Does the temporal sort of attenuation of that work matter at all?
I think that a jury could easily find that it does because the nature of the progression of floodwater and how it needs to be drained, the county is responsible for that drainage. And you see this a lot in a lot of the Hurricane Harvey cases where there was issues with drainage. But the fact that the county did not complete the drainage all the way to Leona Creek, then it did cause a backup onto the property in question. So,
but not until your clients had done the other work that they did, right?
Well, this kind of raises that issue of the fact that flooding is a unique kind of issue that only happens during significant rain events. So you can't really say that it only happened after they did the work on their property and that was the only causation.
But factually, that's true, right? It didn't flood until, the respondent's property didn't flood until after your client had completed.
The record, there's no evidence in the record that it flooded prior to, but it does not preclude the possibility that the work or failure to widen the tributary by the county contributed to the actual flooding.
Because there weren't any significant storms in that intervening time?
There
Is there
wa-
evidence of that?
There's no evidence in the record of that. It's
Either way.
just, but there's some cases in this court under, I guess it's Stanfield is the case I'm referring to, that where there can be more than one proximate cause of an injury, where the Victoria County's negligence could have been the first cause in a series of events that basically the original negligence that caused the damage in the Kolle's property. I do want to address the harm issue because the respondents did say that there was no harm, but as in this court's opinion in Gregory, allowing the jury to determine the proportionate responsibility of all responsible parties is a significant substantive right, and therefore it is harmful. I also wanted to address the waiver. They did try to argue that it was waived, like briefing waiver, but in the appellant's brief, they did acknowledge and cite to quite a bit of evidence in the record, and it is recognized in the opinion under footnote 9. So if there's nothing else, I'd like to move on to the next issue. Under the proportionate responsibility of the plaintiff, this issue, I think, it's kind of got an interesting question because of the fact that appellants withdrew the issue in their reply brief, whether or not this court can actually acknowledge or decide this question, because it does present a very interesting question for the court as whether or not there's a common law duty to exercise care to prevent one's own property damage. I think it's an important question for Texas jurisprudence, but is it before the court is a question. And one of the issues I think that is important to acknowledge is that when you're kind of following the analysis and GT Leach builders, when a court of appeals addresses something that was not addressed by the appellant, which analogous to this, the appellant withdrew the issue, therefore it wasn't addressed by appellant. If it's in the opinion and they do reach the merits of the opinion, then it can be raised for the first time in this court. I think under that theory and that analysis, this could be before this court. And I think in this particular issue, it does kind of, it's consistent with the purpose of Chapter 33. This court has held before in a very similar statute that that you have to be responsible for your own injury-causing conduct, but doesn't specifically say that any property damage conduct. So that would be an issue that I think would be important to clarify for Texas jurisprudence. I guess I'll move on to the next issue. And the punitive damages, I think with this issue, it kind of raises several questions, one of which is the cap. When in this particular issue, the cap should be based on each day, per defendant basis, and under 41.006, when there's an action where there's two or more defendants, An award of the exemplary damages must be specific as to a defendant, and each defendant is liable only for the amount the award made against that defendant.
And so the jury and the judgment did that. There are specific awards for each defendant. But it seems like the part of the cap statute that's relevant here is 41.008, which says the exemplary damages awarded against a defendant may not exceed 2 times the amount of economic damages. And I think if you're construing that in a parallel way, it would be 2 times the amount of economic damages awarded against that defendant. Do you agree with that?
That's what we're saying,
Okay,
but that is not what happened here.
Well, why not? Because the amount of economic damages awarded against each defendant by the jury and, in the judgment was included the joint and several liabilities. So it seems like if you just look at the statute, it was calculated correctly, because the award does not exceed, the award of damages against each defendant does not exceed 2 times the amount of economic damages awarded against that defendant.
So one thing, in the judgment, they only awarded joint and several liability with Valerie and K&K. So David was actually left out of the joint and several liability. His particular damage award was $70,000 when you take out the loss of use damages, which the Court of Appeals found was improper.
But aren't you complaining right now of the Valerie's the assessment of punitives against Valerie?
I'm so sorry.
Aren't you complaining about the assessment of punitives against Valerie?
We're complaining about the excessiveness of all of the petitioners.
So I guess the question is, what I'm really trying to get at is if you're saying that Valerie can't be liable for exemplary damages based upon gross negligence, even though the jury found that she was acting intentionally, that doesn't seem to really make much sense, since intentional conduct would be higher on the scale of culpability than gross negligence, right? So can you explain that to me?
Sure. So gross negligence is only available for, punitive damages is only available for gross negligence, not for intentional conduct.
That's not necessarily true. It's available for malice.
Well, malice and gross negligence are not synonymous.
Right.
Malice
And
was not charged to the jury.
I'm not sure that you're correct about that on your issue too, because there's a finding by the jury in question 2A by clear and convincing evidence that each defendant intentionally created a nuisance. And the instruction to the jury on what it means to intentionally create a nuisance is defined as conscious, objective, or desire to engage in conduct or cause a result, which is the same as the way the statute defines malice, a specific intent to cause substantial injury or harm. So I'm not understanding your argument on this sort of single injury, double recovery principle, because the case that you cite, which is Birchfield, has to do with where somebody was basically awarded double exemplary damages under the DTPA and under regular exemplary damages, and we said you can't do that, but we don't have that here. And I understand your argument about, well, you can't choose gross negligence, negligence and gross negligence one way, and then you can't choose intentional for some things, because for Valerie, I guess you need the jury's finding on intentional nuisance in order to get to conspiracy. But it seems like you get to exemplary damages through the intentional conspiracy finding as well. I'm sorry, the intentional nuisance finding, and so there's not an inconsistent election being made here.
The best case scenario on that issue would be dropping the joint and several liability, because if they were to have to elect either intentional or negligent nuisance, they would elect the gross negligence, which would drop.
Why wouldn't they elect the intentional nuisance?
Because they would have a higher recovery on the gross negligence.
Why?
Or I'm just saying, like
I don't think that's true, so I'm
Okay.
trying to get you to explain to me why that's the case.
I don't know that issue's that important. Like, I'm willing to concede that we can drop that one. I think the bigger issue is on the punitive damages cap and the way that they awarded that. Another issue with the punitive damages is that it is required under this court's jurisprudence that when when a regular damages are reduced, that the punitive damages must also be reevaluated, and that was not done by the Court of Appeals. I'm just about out of time. Are there any other questions?
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Kolle will present argument for the respondents.
Mr. Chief Justice, and may it please the court. Before I get started, I just wanted to acknowledge that my clients, the Kolles, are here today and wanted to thank them for coming. So I was originally going to start on the nuisance issue and whether we would have to choose between gross negligence or the malice finding, but it appears that issue has been conceded. So instead I will start.
I didn't hear that issue as to the double recovery was conceded. It may be that in terms of the election that it might not be different, but I didn't hear that about the double recovery challenge.
Yes, Justice Bland. I'll address the double recovery issue really quick. So there really is not a double recovery issue in this case because there is just one set of damages, the $175,000 for the reduction in value of the property. And so that's our set of damages. And the question is whether Valerie could conspire with that if the only basis for our exemplary damages is gross negligence, because of course you're not able to conspire with negligence. But as Justice Busby had pointed out, effectively we really have a malice finding here, and no one disputes that you're able to conspire with malicious conduct, because the jury found that they acted intentionally and that they intentionally caused a nuisance, which if you add both of those together adds up to malice. And so there's not really...
And actually found it by clear and convincing evidence, right?
Correct.
As a predicate for exemplary damages.
Correct.
And I guess that's why the question about the amount of exemplary damages was predicated. One of the predicates for that was mentioned to the jury was the intentional nuisance finding by clear and convincing evidence, right?
Correct, Justice Busby.
So should we basically just say there's no inconsistency here because what the trial court awarded you is consistent with a recovery on your intentional nuisance theory right down the line, and we could ignore the negligence and gross negligence findings because the intentional nuisance findings and the exemplary damages findings and the conspiracy are sufficient by themselves to uphold the judgment?
Yes, Justice Busby. I definitely think that that's an option open to the court, but I can also, I think that there's other options open, but that is certainly one of the theories that we argued at the appellate court. And if this court finds that persuasive, I think that is certainly sufficient for the court to affirm all of the damages awarded on that basis.
One thing I'm sort of curious about is the verdict internally inconsistent? Like, I find it sort of weird that the jury says it was asked, did they intentionally cause this nuisance? Yes. Did they negligently cause this nuisance? Yes. Aren't those incompatible with one another? If I'm driving my car and I hit Justice Young and he sues me for an intentional tort and also for driving negligently, the jury says yes to both. That doesn't seem to add up to me, and I'm curious why it makes sense here.
Well, Your Honor, I actually don't think that it's inconsistent in this case because it took place over a long amount of time and various actions kind of combined to cause the one damages, the $175,000 in loss in property value. So I don't think that the jury answers are really inconsistent. Actually, as I was preparing for oral argument, so I'm sorry, but this is not in our briefs, I did find a appellate court decision that really says what we're saying here. That's Finley versus PG, which is 428 SW 3D 229. And the court in that case, it's the First District Houston Court of Appeals, says that there's no inconsistency between a finding of malice and gross negligence because it's completely consistent for someone to meet the objective and subjective prongs of gross negligence, but also to have intended their conduct. And actually, on the specific question that you're asking, Justice Hawkins, I went back and watched the oral argument for cross-text in preparation for this case, and it was very interesting there. The justices asked both sides, well, do you think that finding a negligent nuisance, negligent creation of a nuisance and an intentional creation of a nuisance are contradictory? And both sides in that case said, no, in the case of nuisance, I don't find it contradictory. That would be a contradictory verdict. In cross-text, that was not actually at issue because the jury in that case had said no to an intentional nuisance and had only said yes to a negligent nuisance. But here the jury found both an intentional nuisance and a negligent nuisance. And I don't think
there was no objection to any sort of contradiction in those findings, so we have to harmonize them.
Yes, Your Honor. Yes, Justice Busby. There was no objection to any sort of contradiction. And as you had suggested earlier, even if this is a situation where we'd have to elect one theory, if we did the intentional nuisance theory and it was malice based on what the judge and based on the instructions and finding it by clear and convincing evidence, then that wouldn't be contradictory at all, or even arguably contradictory. I do want to touch on the Victoria County issue. It seems like on this issue we're almost kind of talking past each other. Petitioners spend a lot of time, my friends on the other side spend a lot of time discussing the differences between responsible for and liable for, but it doesn't really make a huge difference in this case because there's no evidence whatsoever that anything Victoria County did caused any of the Kolle's injuries that they're suing for. The temporal disparity is very important in this case because Victoria County took all of its actions that they're complaining of before the Kolle's purchased the property as is. And so they purchased that property with all of the conditions that existed at the time. And so Victoria County could not logically have caused them any injuries. So they're focusing on the words responsible, but I would focus on the words for any portion of the claimant's injury or damages. The injury or damages that we're complaining about, the legal injury that we're complaining about, is the nuisance, which is the flooding, which on our property, on our client's property, which did not start until after the Kucheras had taken the actions and built the berm and other obstructions that caused the water to back up onto the Kolle's property. There is no, this is not an issue where, oh, well, we didn't sue Victoria because the statute of limitations would have expired, or we didn't sue Victoria because they have sovereign immunity. That's not the issue here.
You're saying you couldn't sue them because you bought the property as is and their work was done before that.
Exactly. It's just that they didn't cause, by definition, they didn't cause any of the claimant's alleged injury or damages. So it's even more fundamental than that. Because I do worry that if this court were to accept my friend on the other side's argument, there would be no stopping point. If a caveman digs a hole on your property and it causes water to pool, then that would be a responsible third party because he's responsible for the course of water through your property.
Well, if that's why the water's pooling, then why wouldn't the jury want to know that the caveman's partially responsible for the water pooling on the property?
Because it's not the damages, because to go back to what I was saying earlier, that would not be a portion of the claimant's alleged injury or damages. Since the Kolle's took the property as is in 2013, there's no damages that they caused. Now,
To the Kolle's. They could have caused damage to the property.
They could have caused damage to the property, but there's no damages that the Kolle's are claiming as a result of any action.
The responsible third party statute is intended to have the jury evaluate other causes of harm when, for some reason, the plaintiff cannot sue or is barred from suing the party. Like, for example, an employer that can't be sued because of the workers' compensation bar, or a governmental unit that has immunity. But if there's evidence that that one of these parties was also responsible, they are submitted. You seem to be saying that we should look at it from the perspective of whether there's an ability to sue, as opposed to a percentage of cause.
No, Justice Bland, thank you for this question, because I really want to clarify.
Okay.
We are not saying that the problem is that we're not allowed to sue Victoria County. We're saying that the problem is Victoria County didn't cause any portion of our damages or injury
You're basically
complained of.
saying there was no evidence
Yes, if-
for which the trial court shouldn't have submitted, because there has to be some evidence that they did cause or contribute to cause the flooding.
Correct, and this was a motion to strike, it's not that the judge didn't allow the designation of Victoria in the first place. This was a motion to strike under 33.00, under 33.003 L, which says that after an adequate time for discovery, a party may move to strike the designation of responsible third party on the grounds that there is no evidence that the designated person is responsible for any portion of the claimant's alleged injury or damages. And so it's those last words that we're really hanging our hat on. There's no evidence that Victoria County, by doing something in 2010, could possibly have caused any injury to the Colles who took the property as is in 2013. Because, you know.
That's the part of it. I think could not have caused the flooding is the answer, that there's no evidence of that. Whether they took it as is or not as is,
Right.
shouldn't matter.
Well, that's one direction that the court could go, that it shouldn't matter. But I'm also saying, you know, fundamentally, when you purchase a piece of real property, you take it with all of the conditions that exist. And if you take a piece of real property with a bunch of trees, it doesn't matter that last year, before you purchased the property, somebody had destroyed a bunch of trees, because you're taking the value of their property. Remember, the damages in this case was loss of value.
That seems like a reason that maybe they could not have sued the county, right? Because they made the purchase, they purchased the land as is, those were the terms of the deal, and so you can't hold them responsible for if what they did to the land caused the flooding. But it seems to be a different question to say, does the fact that they dug up the tributary, that they didn't dig all the way to the tributary, did that actually contribute to the result of the flood, in addition to what the neighbors did?
Right,
It's a different question.
Yes, and Justice Huddle,
So how do we know that there is, how do we say that it was imprudent, that the evidence that it was imprudent to dig the way that Victoria County did is not some evidence that it caused, that it caused the flooding or contributed to the flooding?
Well, so when Victoria County did that in 2010, you know, the Colles purchased the property in 2013, and they didn't have any issues with flooding until the Kucheras started building the berm and the road and the other obstructions that caused water to back up into their house or into their property.
Would you agree that if it was imprudent or not doesn't answer the question whether there was a cause, whether it was causal, and here there is no evidence that it was causal?
Yes, Your Honor. Yes, Justice Huddle. There's no evidence that it was causal. There's no evidence that Victoria County was responsible for any of the harm that the Colles are claiming, or the legal injury for the nuisance. I do want to address really quick also the question of the Colles' own negligence, because I think this is another issue where the parties are kind of talking past each other. So theoretically, I don't see any reason why in Chapter 33 you wouldn't submit a comparative fault question for property. For example, if a plaintiff is driving an expensive Lamborghini through a green light, but they're looking at their phone, so the plaintiff is negligent, and the defendant runs a red light and hits the plaintiff and destroys their Lamborghini. If the plaintiff sued for negligence on that, of course, if the plaintiff was looking at his phone, even while he was going through a green light, you would submit a comparative fault question that would offset some of the damages of the negligence. But here, it's a different, this case is fundamentally different. Plaintiff sued over nuisance, and the nuisance was the flooding of the property. A nuisance is a legal injury, as this court famously said in Crosstax. There is no evidence or even argument on the other side that the Kolles caused or contributed to the flooding of their own property. Even in this case, if there was evidence that the Kolles had built like a trench around their trees that caused their trees to be flooded, then that could be a comparative fault question. But here, the only quote-unquote comparative fault that they're talking about, that my friend on the other side is talking about, is the bulldozing and the spreading herbicide. But the problem with that argument is that those go to damages and causation. Defendants were free to argue and did argue that no, the flooding is, the nuisance is not what caused your trees to be damaged or what hurt your property value. It was these bulldozers. They were free to argue that, they did argue that, but that doesn't go to comparative fault. And here's a good example from the car example. Say instead of looking at his phone while he was driving through a green light, the plaintiff had instead negligently applied a bumper sticker, which completely destroyed the Kelly Blue Book value of his Lamborghini. It was a really bad bumper sticker. You can fill in the blank of what it said. Just totally destroyed the value of his Lamborghini. That would not be comparative fault. That would go to damages. The defendant wouldn't say, they wouldn't say that, oh, well, plaintiffs were comparatively at fault because they put a bumper sticker on their car that's really bad. They would say, plaintiffs destroyed the value of their car, therefore, when my client hit them, it's the difference between what the value was and what it is after the legal harm is large. And so that's more what's happening in this case. So just on a fundamental level, it's not, and I also think with this court's importance given to property owners, it would be really dangerous to rule in that direction because plaintiffs have the right to do what they want with their own property. The reason they were applying herbicide and...
So running short on time, I wonder if
yes.
you would give us your best points on the exemplary damages issues. There are a number of them. And one thing I want to ask you about in particular is, does a court of appeals that reduces a damage award automatically need to reevaluate the constitutionality, the ratio of damages that's constitutionally permissible, or does it at a minimum need to ask the trial court to evaluate that? That doesn't seem to have happened here.
Well, so the case that's relevant to that issue is the Bunton case, and I think that the Acadia Horizon versus Acadia case cites the Bunton case for that. And I would say that there's two ways to distinguish Bunton. I would say here, any argument that they could have made about that arose before the trial court reduced, before the appellate court reduced our damages. In their appellate court brief, they had argued that the court had improperly calculated the cap and had cited Horizon versus...
I think this is a different question, though, not about the cap, but about the constitutional restrictions on the amount of damages. And we've said in the attorney's fee context, for example, because one of the inputs into the equation of whether attorney's fees are reasonable is what the damages are. If the damages are reduced on appeal, then you get to, you have a new trial on attorney's fees. So why shouldn't the same logic apply where either the trial court or the Court of Appeals should take another look at the exemplary damages under the BMW factors?
Yes, Your Honor, and one thing I would say on that is that even in this court, first of all, it was an unbriefed issue in their petition for review, but even in the brief on the merits, they did not discuss the reprehensibility factors under the BMX guidepost. They simply talked about the damages cap. And so that's why we focused on the damages cap. So I would say one way this is distinguishable from Button is that they not only couldn't have raised it in the appellate court, which they could have and did, but even in this court, they didn't really brief that issue, especially the reprehensibility factors. I see that my time has expired, but can I make one more really quick point?
If there are no further questions.
Okay.
Well, I do have one
Yes.
question, and that is I'm trying to figure out why it's proper for the punitive damages to be aggregated in the way that they were here just because of the fact that there were multiple owners of the property that received a single injury.
Yes, Your Honor, and I think I would go for that to the structure of 41.008. It says, in an action in which a claimant seeks recovery of damages, the trier of fact shall determine the amount of economic damages separately from the amount of other compensatory damages, and then it talks about the cap. So this is talking about where a claimant is seeking damages, and so I think that for each claimant, the punitive damages cap should be calculated.
So if this had been the same property, but there had been 10 owners of it instead of 2, then we could just have $2 million
With, I think that it should be
against
specific.
each defendant?
I think that it should, I think that is how the statute is written, and
I mean, subsection B seems to focus on the amount awarded against a defendant, not about the amount awarded against a defendant per claimant.
Yes, Justice Young, and my only response to that would be twofold. One is in subsection A, it kind of sets the stage for subsection B, and it's talking about in an action in which a claimant seeks recovery of damages.
But and I can get that if the injury is, I go out and I punch 5 people in the face. Well, each one of them is going to have their own injuries, right?
Right.
But if it's just one injury, it's a car or a property, something that's owned by 5 different people, well, the harm that I've caused it is what it is. So
Right.
I haven't really multiplied, so that I'm not sure what work. I can see how A would be allowing for each claimant to get this if they're distinct harms, but they're not, are they?
Well, it's just hard to get there textually with how Chapter 41 is written. With the, sorry, can I finish answering this question? Yes. It specifically, at the beginning of the section, it specifically defines claimant. And the only thing that they hang their hat on, they seem to agree with us that it's separate to each claimant. The only thing that they hang their hat on is in a cause of action in which a party seeks recovery of damages related to injury to another person, damage to another person, death of another person, or harm for another person. We think that that's talking about situations like the survival claims or a next friend. I just don't think textually that can really apply to here because they both own the property. And they were both harmed in the amount of $175,000 because they both own the property.
So let me ask you one last thing on this, related to this topic. Why would it not be then that we would focus on the harm caused by a particular defendant instead of looking at the entire thing? Say, all right, we know what each one is responsible for.
Right.
And then when you combine that with the fact that we had this massive reduction in the economic damages, the jury and the trial court thought that these were distinct forms of damages, so this amount of punitive damages might be reasonable. Doesn't that at least give us some reason to doubt the propriety of the punitive damages award?
Well, I think, again, 2 things. This is how this court, including in Horizon versus Acadia, and lots of appellate courts have calculated the punitive damages cap on a per defendant basis. rather than on a per
But
judgment
wouldn't
basis.
that mean per defendant, you're looking at the harm caused by the defendant? Because for punitive damages, this is focused on what this defendant has done, not what all defendants have done collectively. What has this defendant done?
Well, so one, you do have the joint and several responsibility, and also that's how Seminole Pipelines, for instance, has calculated it, and I think that the textual hook for that in Chapter 41 is, sorry, I'm trying to get to the relevant language in Chapter
41008 says that the cap is 2 times the amount of economic damages awarded
Correct.
against the defendant. So isn't that the relevant comparator? I mean, it says that 2 times the amount of economic damages, but it says before that exemplary damages awarded against a defendant. So I think what it's saying is what you look at for calculating the ratio is the amount of economic damages awarded against the defendant.
Well, so that is exemplary damages awarded against a defendant.
Right, but what Justice Young was asking you is what do you look at to decide what gets multiplied by 2? And the statute seems to say you look at the amount of economic damages awarded against the defendant, which in this case would include joint and several liability, right?
Yes, in this case, so that is one way that this court could avoid even having to reach this complicated question, since it includes joint and several liability, exactly. So that's one way that we would win either way. But just to answer Justice Young's question, it says 2 times the amount of economic damages. It doesn't repeat that awarded against a defendant.
Don't you think that's implied by the fact that the language before it says exemplary damages awarded against a defendant may not exceed 2 times the amount of economic damages awarded against that defendant?
I actually don't think that it's implied because I think that...
So you think if this were a case where there were 10 defendants and $1 million was awarded against all of the defendants together, each defendant could be liable for $2 million in punitives?
I believe that is what, under the cap language, that is how Seminole Pipelines and other cases that have considered caps have handled it.
Even if there's no joint and several liability?
Well, this is an academic question in this case.
Well, we have to write this for other cases too.
Right, okay. Well, unfortunately, and the Seminole Pipeline said this, that
I'm
this
just
statute...
asking what the statute says.
I do think, yes, I do think that is what the statute means. I don't think that's correct.
And beyond that, if there were 10 owners of the property, it's $2 million for each of the 10 for each of the 10 plaintiffs too, right?
Yes, but of course, if it had...
That's going to work out to some pretty interesting math, right?
It could, but of course, that's how courts have interpreted the cap. And also, one check on that is the constitutionality, the reprehensibility factors in BMW and the constitutional cap. But yeah, that is how I read the language, because I don't, it says 2 times the amount of economic damages, and it doesn't, and it would have been very easy for the legislature to say 2 times the amount of economic damages awarded against the defendant, to refer back to that. And instead it just says the economic damages, and it's talking about in the action of a claimant. And so I do think that how this is worded, and
Thank you, counsel. Your time has expired. Any further questions? Thank you very much, Mr. Kolle. Ms. Clothier, you have 5 minutes.
Thank you. May it please the court. I'd like to address 2 points on the punitive damages. This court actually has decided this issue in Horizon Health, and it explained that punitive damages must be based on the harm each individual defendant caused rather than the harm for which each individual defendant is jointly and severally liable.
So Horizon was applying the BMW versus Gore constitutional excessiveness issue, and what we said there, challenge that you can make to punitive damages, the constraints that the Constitution puts on the levels. And what we said is, because those factors are individualized or on reprehensibility, then we've got to look at this on a per defendant basis, regardless of whatever a state joint and several liability regime is, because this is a federal constitutional question, not a state statutory question. But here we just have a state statutory question. So why shouldn't we be looking at what the statute says rather than at what the federal constitutional due process you know, whatever BMW derived from due process that says here are the factors that, you know, may also constrain punitive damages awards?
I think it's just the fact that it's based, the statute does say liable for the amount made against each defendant. I think that you
Well,
can.
and there can be no joint and several liability for punitive damages. So if you allow punitive damages to be calculated based on a joint and several liability amount, is that just a different way of imposing joint and several liability for punitive damages?
I think it could be. And I think one of the issues that we have to address in this case too is that they only awarded exemplary damages against David and K&K, and they only did joint and several liability against Valerie and K&K. So David would presumably only be liable for his cap to be based on his individual, because he was not joint and severally liable. So even if the court were to adopt the premise by respondents, then David's would still need to be reduced based on that idea. And also, I wanted to mention, based on this question of whether or not claimant should include all individuals, plaintiffs, or just each individual plaintiff, the court had decided, kind of construed a very similar statutory provision, that was section 33.001 in Drillick systems, and did construe that as meaning claimant that includes all individuals seeking damages. So I think that it's analogous to the provision. In my final time, I'd like to just mention on the Victoria County responsible third party, I don't think the timing of the purchase is relevant. I don't think the purchasing the property as is relevant. The issue is whether or not what the non-prudent acts of Victoria County produced some of the damages, or may have produced some of the damages. That would require it to go before the jury for them to make the decision of whether or not it meets the standard of 33.004. So if there's no further questions,
Any further questions? Thank you, Ms. Cloutier. Thank you to all counsel.
Thank you so much.
The case is submitted, and the court will take another brief recess.
All rise.